Hello, I'm David Brewster, a partner in the Allens Competition Group, and I'm joined today by Phillip Williams, the Chairman of Frontier Economics, to talk about the draft report of the Harper Review into Australia's competition laws. One of the most controversial aspects of the draft report is likely to be the proposed amendments to the misuse of market power provision. It's proposed that the law will be amended to prohibit a company with a substantial degree of market power from acting with either the purpose or the likely effect of substantially lessening competition in a market. That's a change from the current test, which focuses largely on the purpose of the conduct and whether it is to eliminate or damage a competitor. It's proposed that there will be two defences to this new prohibition, however. So Phillip, as an economic expert who regularly appears in court in this area, it occurs to me that you may well one day, should these reforms become law, have to give evidence in relation to their application. And I thought we might talk about the defences in particular, because to me they seem the most problematic area. The first requires that the conduct be for a rational and legitimate business purpose. It seems to me that while the Harper panel talked about the need to remove the former taking advantage test, this new defence really seems to incorporate much of the substance of that previous requirement. What are your thoughts?
I agree with what you're saying, but I've always thought that the take advantage test, the current test, is actually a good element, because what it does is to try to distinguish between conduct that is competition on the merits, basically on the basis of efficiencies, and competition or taking advantage means basically stitching things up, using your market power to gain a competitive advantage over your competitors. So it seems to me conduct should be allowed if it's creating economic efficiencies, but it shouldn't be allowed if it's stitching things up.
Yeah. So effectively a similar test, but the onus of proof has been reversed under this new defence?
The proposal is to reverse the onus of proof, but I don't have any particular problem with that, because at the moment, under the current test, corporations that are accused of violating the section, they have to establish that the conduct is consistent with markets in which they wouldn't have such market power. So I don't think that's a big change. It's just really acknowledging what is the current position anyway.
Yeah. So moving on to the second limb of the defence, and both of these limbs of course need to be established, it's that the likely effect of the conduct is to benefit the long-term interests of Australian consumers. To me, that seems to be incorporating the type of analysis that's more commonly found in an authorisation context into the misuse of market power provision, despite the fact you can't actually authorise a misuse of market power. And my main other concern is some of the language there, Phillip, about long-term interests of Australian consumers. It's completely untested, provides no certainty to businesses, and I can see, quite frankly, High Court appeal written all over this. What are your thoughts?
Well, I have a rather perhaps simple-minded or more simple-minded view of the words. It sounds very much to me like economic efficiency. So the second limb of the defence seems to be that any business that's accused of violating the section, if it's going to get off, has to establish, among other things, that the conduct would promote economic efficiency. Now, I agree that this is problematic for this reason. I've always thought that if you could establish that conduct promoted economic efficiency, it would be very easy to establish that it was consistent with what you would do in a more competitive market. But the causal connection doesn't work the other way around. That is, just because conduct's consistent with what would happen in a more competitive market, that doesn't mean that you've proved economic efficiency. I'll give an example. In the Boral case, Boral was producing concrete masonry blocks to put in buildings, and there was a lot of excess capacity because there was a big market downturn. A new entrant entered and a price war started, and firms were eliminated in the course of the price war, and Boral was charging prices below the incremental cost of bidding for particular contracts. Now it seems to me in that case Boral, in my opinion, even if it could be proved that it had substantial market power, wasn't doing anything particularly bad. Right. It was doing what any firm in a competitive market would do if they had the funds. It would ride out a really bad period in order to be there for the next year. But under this test, they'd have to establish that their conduct in pricing low was promoting the long-term interests of consumers. And I think that would be very, very difficult.
Mm. It also seems to me a similar issue might arise in a refusal to supply scenario, where it might be very hard to establish that your refusal to supply was in the long-term interests of consumers.
Yeah, people refuse to supply for all sorts of reasons. They might refuse to supply because they don't get on with the people, they don't trust them or something. But under this, if the refusal to supply substantially lessened competition, that wouldn't be enough. They'd have to also establish that their refusal to supply was promoting the long-term interests of consumers.
Precisely.
Much more difficult.
So I guess in summary, Philip, are you opposed to these proposed amendments to Section 46?
Not entirely. I wouldn't mind the proposal, but the second limb of the defences is very problematic. I think it would be a fine proposal if it just didn't require also that second limb of the defences.
Yes, I agree. All right, Philip, thanks so much for your time today.
Thank you, David.